This is Attorney Jack from Schrold Law Center, and I'm here to answer another question that comes up with the surplus foreclosure situation. A lot of people want to know who can get these funds. Where is the legal aspect of who is owed these funds? Here's the deal. It's very similar to wills and trusts and when you have to go through probate when someone dies. Here's the deal. It's real simple. If the original owner of the property is still alive, they are, and their spouse, if they're married, are owed the funds. These are the people that were on the deed that owned the property and that also had the debt. So if there is excess funds, surplus funds, that is the first person that is owed the money that's now being held either by the clerk's office or a trustee. However, if that person is deceased and their spouse is also deceased, we are going to follow the laws in the state which determine who is the next heir. The next heir, obviously, is usually if there's any living children from the original owner, all right? If there's multiple children, then multiple people are owed this money, all right? If there are no children, either living or if they're deceased or whatever the situation is, we would then follow the chain of who the next person is that's owed the money. It could be a brother or sister. It could be a niece or nephew. It could be a grandparent for that matter. We determine legally, using the statutes in the case law, who is owed this money, all right? Sometimes we will have to play detective and we will actually have to work out through the process exactly who is living and who is owed the money. So that's the story. It's very, very similar to looking at wills and trusts and probate and determining exactly the chain of exactly who is owed the money. But usually it's the property owner. If they're not alive and their spouse still is, it's usually that person or their children. We'll see you on the next video.